Regards to that breaking news story we had about Public Protector Busisiwe Mkhwebane suffering another defeat in the courts. The North Gauteng High Court Judge Tolme has just ruled that Mkhwebane must be personally liable for a percentage of the legal cost in her Estina report. She must pay 85% of costs in her official capacity, as well as 7.5% of costs in her personal capacity. Let's get the latest now from Sipho Stearman. Sipho, a very good morning to you once again.
A very good morning to you once again, and our viewers at home. We continue to get reactions, of course, from this latest cost order against Public Protector Busisiwe Mkhwebane. Personal cost order, as you mentioned there, she's been ordered to pay 7.5% cost order both for DA and Casac Council. But right now, let's get reactions from the spokesperson of the Public Protector, that is Oupa Segalwe. Thank you very much, sir, for your time. Another cost order granted against the Public Protector. The judge also had harsh words and said that she failed the people of Vrede in her report. Your reaction to this?
Well, the Public Protector disagrees with the outcome today, just like she disagreed with the first aspect of it earlier this year, because she believes that for one to incur personal cost orders, it should have been proven that she acted fraudulently, she acted recklessly, and that there was gross dishonesty on her part. And those have not been proven in this particular matter, which is why she's disappointed with the outcome, and she will be challenging it, just like she indicated when the first aspect of the judgment was handed down a few months back, that she would be challenging this particular outcome because she fundamentally disagrees with it.
We know that the Constitutional Court has found against her in the Reserve Bank judgment, and the cost order was upheld there. So does she have confidence, or does she have any legal leeway to stand on to challenge this finding against her? Because the judge, particularly in this case, said that her conduct here in this Vrede Dairy Farm matter was far worse than the Reserve Bank matter.
Well, each case is dealt with in terms of its own merits. So we cannot look at what was the state of play in relation to the Bangkok matter and want to apply those things here. So the Public Protector, as I said, does not agree with the outcome of this judgment, because if you study it, you will not find any establishment that she acted fraudulently, recklessly, and she was involved in gross dishonesty. Those standards have not been proven.
All right. I mean, in the Absa Bangkok matter, we understand the figure that she's expected to pay is at around 900,000 rands. But now here again, she has to pay for 7.5% of fees for two councils, both for DA and for Casac. I mean, how is she taking this, and how is she likely to finance this?
Well, for the Public Protector, it's not so much about the money, but the issue of principle. Because left unchallenged, this kind of ruling can have devastating consequences for the Public Protector, the office, and the incumbent who will follow long after her term of office. And so it is important for her to challenge these things so that the law is cleared as to what exactly is meant by do your investigations without fear, favor, or prejudice. What exactly is meant by Section 5, Subsection 3 of the Public Protector Act, which insulates the Public Protector from any sort of liability when she has conducted her work in good faith. So those things need to be clarified so that incoming Public Protector know, because these judgments are not just for her. They set a precedent which will be used against whoever will occupy this office in the future.
All right, and does the Public Protector stand, though, behind her Vrede Dairy report, despite these damning findings against the report, that she failed the people?
She does, which is why she is appealing that matter. She has, on numerous occasions, indicated that this investigation was concluded in 2015. That's more than a year before she came into office. And then if you look at the provisional report that was published then in 2015, you will see that there were no findings against any politician, precisely because there was no complaint against any politician. There were no allegations against any politician. Even when you go to the remedial action, you will find that The remedial action then was saying the Premier must take action against the officials, and that's what she ended up with herself. Now people are trying to suggest that she tampered with that report. Never mind the fact that it has no status because it was a draft.
All right. Well, thank you very much. That is Oupa Segalwe, the spokesperson of the Public Protector, just reacting to that judgment here that the Public Protector is liable to pay the court order in the Vrede Dairy Farm matter. But also another bit of news, Blaine, you did mention it's a busy news day, is that the North Gauteng High Court has agreed that the Public Protector's record into the CR17 campaign by that she was investigating her record into her investigation into that Bosasa report will be concealed. You remember, of course, the president had petitioned the High Court to conceal this record, and then we reported yesterday that the two parties will be coming today to meet with the Deputy Judge President and, of course, then decide on a way forward. And as we understand it from Oupa, maybe since I still have him here, I can get him to comment on that it has been agreed that the record will be concealed. Oupa, that's what you say, that is the word from the legal team of the Public Protector, that it will be concealed. Does the Public Protector, protest against this, or does she have any say into whether this record should be concealed or not?
Well, again, the Public Protector is disappointed with that decision because she strongly believes that the public has a right to know in this instance. But also, she's of the view that the President's legal team did not make any basis for the kind of decision that was taken. If you recall, in their letter, they only indicated that they suspected that that information was obtained illegally, and the Public Protector has moved to clear all of that to say she obtained this information from a statutory body, the FIC, so it could not have been obtained illegally. But you see that the decision has still been granted. But also, what was interesting...
So the Public Protector's Office is not happy with that. They feel the record should be left to the public so they can make their own conclusions. Oupa, thank you very much. Well, there you have it. The Public Protector's Office say through Oupa, the spokesperson, saying that they are not pleased with the decision to conceal the Public Protector's record as was requested by the President, but that is the decision that has been taken here, and the record will be concealed from public consumption. And the Public Protector, of course, has also reacted strongly against allegations that she obtained some of the information in the CR17 Bosasa investigations illegally, saying that she used the Financial Intelligence Center to obtain all her information, and saying that nothing was unlawful. But the courts have decided that the record will be contained. Another matter, in the Vrede Dairy matter, the Public Protector has been asked to personally pay costs for both councils, the DA and Casac, 7.5%. A lot of activities here in the High Court involving the Public Protector. And with that, Blaine, is back to you.
All right, Super Stearman, live for us from the capital. Appreciate that update to bring us more breaking news here on the agenda with regards to